All yours, Tami.
All right, so glad that all of you could join. I'm navigating to my screen here, and here we go. Please put your questions in the chat. I will probably have time at the end to get to some specific questions, and I may be answering questions that you have as we have this talk. My name is Tami Jackson. I'm the public policy person and legislative liaison for the Wisconsin Board for People with Developmental Disabilities, and I'm one of the lead people who actually led the charge and helped pass the bill that became the law that we know is supported decision making. And subsequently to that, we also worked with the legislature to pass Guardian training, which is just going into effect, so that there are some additional resources for people who are interested in alternatives to guardianship and want to know what they might be getting into. If they are choosing to pursue guardianship, what that all entails. And we've done a lot of other work as a board on self-determination and helping people understand the choices that they have, not only as individuals, but as families. So tonight we're going to be talking, this is a transition talk. So we're going to be talking about a lot of the things that we know families are often concerned about as you are about to have a young adult become a full-fledged adult. And we're going to talk about not only the supported decision-making, but other decision-making tools. We have found that many people have only heard about one thing by the time they get to where you are, and that is guardianship. And so we do spend a lot of time talking through what are some of the things that families may want to consider as they're trying to figure out what is the best tool for the person that is going to become an adult. And we'll talk about Wisconsin specific laws. So I always start off with what the law is for all of us in the state. Wisconsin law presumes that everyone is competent to make their own decisions. And the state law says that if you're 18, you're considered an adult. There's nothing magical about 18. It's just a number. It's one more than 17 and one less than 19. And the law puts that number 18 as the line in the sand between child and adult. Not everybody who's 18 is in the same position to make decisions. Some of us have had more practice than others. Some of us are really good decision makers at 18. Some of us look at our 18-year-old selves who are now older and go, ooh, I don't make the same decisions that I do today as I did back then. And the important piece here is that everyone, there are lots of able-bodied people who at 18 make decisions that they wouldn't make at 40. And decision-making is a learned skill. You need practice at it. We get practice at it throughout our lives. There are always decisions that we haven't had to make before that we are faced with. And there are lots of ways that people get practice. And your person has hopefully already had practice making decisions, even if you don't know it. Lots of things that we do with children are really helping them practice making decisions. If they decide what to wear, they're exploring their preferences. What do they like to eat or not eat? Who do they want to choose to spend time with or not? What do they like to do in their free time? How are they able to practice with decisions that have increasing responsibility or consequences? No, I don't want to go to English class today is a very different discussion or a decision than should I get in a car with a stranger, for example. But people with disabilities should have practice making decisions, and they will continue to have to make decisions throughout their lives. So there's nothing magical about 18, but Wisconsin law says we assume that everybody's competent. Now, there's a difference between what the law says and how our culture and society presumes certain people are or aren't able to make decisions. And there's a word for this. There's a cultural bias. It's called ableism, and it presumes the exact opposite of what our law says. It presumes people with disabilities are incompetent. And some of you may have seen this in your interactions with, maybe people you work with or family members or professionals even. What does it look like? A lot of times people with disabilities, they're always learning, just as all kids are. And they are learning from the behavior of others towards them too. And sometimes when people, professionals or others, assume they can't make decisions or make decisions for them or exclude them from conversations that are about them, that is teaching them this idea that they, because they have a disability, are not competent. We presume other groups of people aren't competent as well. This also happens to older adults, especially older adults that are facing a degenerative, a cognitive decline. We presume it of people with mental health issues often because it's easier sometimes to do that. And you may have, I have a list here that I won't go through the whole thing, but you may have experienced this, and it can be subtle. It can be something that you wouldn't necessarily notice. But if you're in a meeting and there's a question asked, and your person is sitting right next to you, and they're asking the question of you and expecting you to answer on their behalf, that is absolutely ableism. That is somebody who is presuming that the person whose life we're talking about doesn't really have a say in it, that there's somebody else that should be making that decision or talking about it. And some of the things that people with disabilities learn with this are pretty damaging, and I have them listed below. What does it feel like to be kind of presumed to be incompetent? It means that you've learned you let others speak or decide for you, that you maybe aren't allowed to have preferences or that they don't matter, that I can't say no, or I have to comply. I don't have control over my own life. You might be in a position where you have to prove your competence. And frankly, if any of us had to prove our competence in a given area, it might be hard. That's not something we have to think about, because people look at you and say, oh, you're competent, in the way that they don't with my colleague with a wheelchair, for example. And they don't get the practice necessarily that they need to be able to make decisions. It's no surprise that if you feel like you don't have control over your own life, that feels bad. Self-determination is a fancy word for, do you get to make choices about your own life? And people who get to do that tend to be much healthier. They're more independent, they're more well-adjusted, and they're safer, because they've had practice and they know that they have a say in their own lives and they have autonomy. They're much better able to recognize when something isn't right and resist abuse or report it. So you're a transitioning parent, assuming everybody here is parent. And I just this slide is for you. I want you to know that we understand what's happening to you right now, that there is lots of stuff coming at you, and all of it's happening at the same time. So you're being asked to do major administrative tasks that are not easy to understand and complete, correctly the first time. You're being asked to make major decisions about, long-term care. You might be making a decision about whether to continue school until age 21. Your healthcare professionals are changing from pediatric to adults. You might be, interacting with a variety of different agencies, Division of Vocational Rehabilitation, other public assistance programs, Medicaid. All the while, you're also doing all the normal things, right? Managing your household, going to work if you can, because family caregivers have a tremendous amount of stuff that's expected to them, and taking care of other children or older adults in your life or grandkids or whatever the situation is. It's a lot. And families often describe feeling like they're in a kind of an administrative cattle chute, or they're just filling out and just going on to the next one. It leaves decisions. It leaves very little time to really think through in a very concrete future planning, more than the next 5 minutes kind of way. And unfortunately, this is the time when everybody wants you to make a decision right away. And it's also a decision that you probably need some time to sit with and think about. And for a lot of families, one of the things that they have to think about is, does my person, or does the person as I see them right now at before 18 need some support making decisions? And this is usually the time when folks get told about, oh, well, of course you're doing guardianship. Now, we just had this conversation about ableism, and the recommendation that people get guardianship immediately if there's a disability, especially if there's an intellectual or developmental disability, is rooted in that. Because guardianship is the most restrictive thing that you can do to anyone. And it's often presumed to be the first or only option for the individual, simply based on, well, you have a diagnosis. And so therefore, somebody else should be in charge of your decisions for a lifetime. We'll talk more about guardianship, but this is kind of people often don't know that they have an array of options, and many of these tools, except for guardianship, can be used in conjunction with each other. So on one side of your screen, you have a green box that says release forms. This is actually a way that we don't think about it, but we give access to other people to information all the time. And it's an easy tool that costs nothing, that a lot of people who support folks with disabilities use. Essentially, your person says, yeah, I am authorizing you to see certain kinds of records or have access to them. Sometimes you might need to sign a release form every time, but sometimes release forms can provide limited access for a long period of time or forever until somebody says you can't have it anymore. And that's really useful, because it gives that person a constant person who has access to their information. And nobody's losing their civil rights over this. Like, they're in control of being able to allow who sees their stuff, just as you or I are, right? Like, we use this stuff all the time. We sign it and we don't think twice about it. So next on there, we got this yellow box that says supported decision-making agreements. I say Wisconsin because we're going to be talking about Wisconsin's law. Other states have different variations of supported decision-making laws, as they do for powers of attorney and guardianship. So the laws are not the same in any of the states. And we're going to be talking about what the law is in our state. Supported decision-making agreements, again, I want you to think about all of these options in this frame. Who's the decider? Who is the person in control of making their own choice, making their choices? Release forms, the person makes the choice of who they want to have access to the information. Supported decision-making agreements, the person makes their own decisions. They're not losing any civil rights. However, they get to decide. They set up their own agreement. Again, they are driving, what do I need help with? And who do I want to support me? And how do I want to be supported? And these agreements can be changed at any time, and you can have more than one agreement. And we'll get into the details of that. But the important piece is, the person is the one who's really there thinking through, what do I need help with? Who would I like help from? And what do I want that person's role to be? Okay. There's kind of this light blue one in the middle. Conservatorship is an option under Wisconsin law. And again, the person isn't losing their civil rights to make their own decisions, but it is a mechanism in the law where they voluntarily approach the courts and say, hey, I would like this person, they pick who they would like to be the conservator to manage my finances and property. I'm voluntarily saying, I need help with this specific thing, managing finances and property, and I want this person to be the one to do it. And the court says, okay. And the court isn't finding them legally incompetent. They're not losing their civil rights. And if they want to change their conservator, or they don't feel they need one anymore, they can apply to terminate that. So it is not a permanent thing. And the conservator has really the same duties as the guardian of an estate, which we will talk about later. So for people whose main challenge is that they need help managing their finances, there are tools that help with just that. And conservatism is in the middle here because, again, the person is the decider on whether they need a conservator and who that person is. And if they don't need it anymore, they are the ones who can initiate the change. Power of attorney, the red column, lots of people use this tool as well, people with and without disabilities. And powers of attorney are used in two major decision-making areas: powers of attorney for healthcare and power of attorney for finances. So again, if your issue is you have financial management, this may be another tool that you can use well to help somebody. And powers of attorney, the person is deciding who they want to act as a power of attorney. So they're picking the person, and then powers of attorney can be written in different ways. I usually use an example of a medical power of attorney for medical decisions because a lot of people are familiar with those. And one way a power of attorney can be written is it isn't in effect all the time. There are conditions that must be met, and then that power of attorney is triggered. And at that point, the agent, that's what you call the person who the individual has decided is going to step in. When that power of attorney is triggered, the agent is now the decider. In a medical scenario, if I were in a coma and Tim's my power of attorney, the doctor says Tammy is incapacitated, she cannot make her decisions. Tim takes over, makes my medical decisions. He does a good job. I come out of it. The power of attorney is then terminated. Well, not terminated. The power of attorney is no longer needed. It is no longer in effect because I have regained capacity and I can make my own decisions. Powers of attorney for finance can work in a similar way. It can be written in a way where it's triggered. It can be written in a way durable that it's always activated. You got to think about that one, because if you have a durable power of attorney for finance, that means you're giving co-equal decision-making to another person of your finances all the time, always on all the time. But lots of people use a power of attorney for finance as well. If certain circumstances are met, there's somebody else who is taking over, bill paying, all of those things. So person is still in charge of picking who that power of attorney would be if something happened. Still in the driver's seat. Little more to my right, the next blue box is representative payee. And this doesn't apply to everybody because it's really specific to Social Security and SSDI. But a lot of people with disabilities and older adults receive those two benefits. So the representative payee is, again, a designation that you apply to the Social Security Administration for, and essentially the rep payee is the person who received those cash benefits, and they pay their bills out of that, and are really in control of their funds. It's a little more to, the individual is probably not applying to SSA, to the Social Security Administration themselves, to say, hey, I want somebody else to receive all of my money and then control how it's spent. Oftentimes it is somebody external to the person who's making that application. So that's a difference, right? It's not a voluntary, often initiated by the individual. And the other difference is the person does lose the ability to control the benefit checks that they are receiving. The rep payee becomes responsible for spending that money. And for a lot of people, that might be the right decision. Like if you have somebody who's incapacitated and you need somebody who's, paying the bills and all of that stuff. On the other hand, we've also seen it where the rep payee receives all the money and controls the money and does not give the person extra money to spend. So, there is some risk if you're the individual in that situation. And the final thing on this kind of continuum, you'll see this arrow on the bottom that says more or less limiting. Less limiting, we're talking about civil rights. So your legal rights to make your own decisions. Guardianship is on the far end, because what that is going to court and petitioning the court to say, this person is legally incompetent to make their own decisions. Court, we would like you to find the person legally incompetent and then take away their civil rights to make some or most of their decisions and transfer that responsibility to a guardian, who is the court-appointed person to do that. So it's really a significant departure. Now, and I will say that I cannot think of a single case where the person who was going to be under guardianship is the one who initiated the petition to the court. Usually it is person external to the person who is made an evaluation on their own and then gone to a psychologist or a doctor for supporting documentation to say, yes, this person should be making their own decisions, they're not legally competent, and they're approaching the court to say, please agree with our petition and make me the guardian. And I don't want you to think that I'm trying to be clear about my explanation. That is not a judgment. There is certainly people who are legally incapacitated and incompetent, and the guardianship is the appropriate choice. But for many of the folks that, at least the young people that we see with intellectual and developmental disabilities, guardianship is often the place where they start when they haven't tried any of these other options, and this is imposed young. And a lot of times families are really, really unaware of what the lifetime consequences of that could be, not only for the individual, but for the person. And like I said, oftentimes people are approaching the courts thinking this is more of an administrative process, and the individual with a disability might be showing up at a court and not even having any idea why they're there, because oftentimes the conversation about should we take away your civil rights is not had with the individual whose rights are being taken. So there are actually the statute has two kinds of guardians. One is the guardian of the state, which is completely focused on financials. And in fact, when we talked about conservatorship, the duties of the conservator are actually the same as the guardian of the estate. The conservator acts in the same way. The difference is the conservator is a person that the individual has chosen voluntarily, and they can choose to unchoose them. The guardian of the state is a court appointed, is somebody that has been appointed because the individual is legally incompetent and must do these things. The other phrase that you hear is guardian of the person, and those those duties are more expansive and they can cover many other decisions than finances, including medical treatment, where the person lives, and lots of really, really important and consequential decisions in terms of the person's daily life. The guardian of the estate and of the person have separate and distinct duties under the law. Oftentimes they will be the same person, but not always. Sometimes you can have a person who only has a guardian of the estate, that's rarer. And sometimes you have a person who has only a guardian of the person and not a guardian of the estate. Oftentimes an individual will end up with both, because if you're legally incompetent, you know, the court is more likely to err on the side of more incompetence rather than less. But it's important to know that these can be two people, but often it's one. We have a few things that this has actually been crowdsourced. I'm not going to read all of these things, but these are things that real people across the state in the last 5 years, in the last 5 minutes, have all heard. And if they're coming from people like you who have told us, yeah, I've heard this has been said to me, or they've asked a question because they've heard this thing. And maybe some of you have heard these things too. The important thing to know is all of these things are not true. And we'll kind of talk about why this is important. A lot of families hear that they have to have a guardian to attend an IEP meeting. That is actually legally incorrect. All you need to do to attend an IEP meeting after a person has turned 18 is ask the person if they want you there in the meeting, and the person says yes, and you're good. Okay. That's all you need. I highlight that one because it is something that is so pervasive out there that most people have heard. No, you do not need to go to court to get your person declared legally incompetent and remove civil rights in order to attend a meeting. The 18-year-old just has to say, yeah, mom or dad can be there. I think it's really important that families understand that professionals also don't have some misconceptions about what a guardian is or can or cannot do. That's one of the reasons we went through, and passed guardian training requirements. It's because, frankly, if I were with somebody who had looked disabled and I said I was the guardian, I wouldn't be challenged. No one would probably ask to see my letter of guardianship, to assess, to even ask for an ID to assess that I really was who I say I am. And nobody would have the knowledge to, even if they received that order, understand what my role is or my limits are. That should be a wake-up call, because I think guardian is a code. Professionals hear and they automatically go, oh, you're the person I need to talk with and you make all of the decisions. And that isn't true either. And the fact that they aren't automatically checking you out to make sure that that you are who you say you are, that is a real sign that they're very willing to listen to somebody who is not the person. Families often think about guardianship as an administrative requirement. And a lot of times they haven't necessarily thought through all of the, lifetime of consequences. Once the court is in the picture, the court is the decider, ultimately. When you're asking a court to declare somebody legally incompetent and having them evaluated in that frame, a lot of families sometimes think that they can tell the court what to do. They're wrong. The court is the decider. And you may want to have a guardianship that is very narrow. And sometimes the court will agree with you. And sometimes they'll say, that's not what we do here, and just take away all sorts of rights that you weren't intending. A lot of times families, because we're so indoctrinated and filling out forms, guardianship form is relatively simple and you just check boxes, and people don't realize that when they're checking a box, they're taking away a whole section of somebody's rights, including sometimes the right to marriage, the right to hunt and fish, the right to vote. Like, you've got to be careful about how you fill out those forms. And a lot of people just aren't aware of what they're doing when they're filling out those forms. The other piece that people think about, there's some a reassurance that, oh, well, if we don't like it, we can just change it later. And that is almost never true with a guardianship for a few reasons. One, once a court has declared somebody legally incompetent, if you go back to them and say, we want to change the guardianship, their question is, what's changed? We found them to be legally incompetent. You also have to prove that this person deserves some subset or their rights back. And for a lot of people, like, it's easy to get guardianship, right? For reasons rooted in, a presumption that, oh, there are certain kinds of people that should be under guardianship that aren't always rooted in that individual. But it isn't something that is easily reversed, and part of it is because judges are reluctant to second guess a previous judge's ruling first. And secondly, it is a legitimate question. You were found legally incompetent at what point in time? What has changed that makes you competent now? Courts are always also in charge of overseeing guardianships. And in terms of future planning, a lot of times I will have parents who are in their 60s and 70s and 80s, and all of the things that they thought would be true have turned out to change over somebody's lifetime. So what works for the next 5 years, when guardianships are kind of put in place, they're a tool that is very good for some purposes, but they are not a toggle switch. They're not intended to be. And so when you do this, especially when it's a young person, what their life looks like at 18 might be very different at 25 or 35 or 45 or 55. And your life will look different too. Maybe there's an expectation that siblings will be in the picture, or that there's extended family who would take over. And maybe that's true when the person's 30, but it might not be true when they're 40 or 60. Sometimes people die early or move or have young kids or all sorts of reasons. And, it's not a particularly flexible tool to really change with those realities. And frankly, we don't know how we're going to age. When you're aging and you're a guardian, there may be a point where you yourself are not able to fulfill that role in the same way you were 30 years ago. And people don't talk about that. People don't discuss it. But again, the court's always in charge. I'm going to finish and then I'll take your hand, Tim. The court's always in charge. So once there's a guardianship in place, there will be another guardian. Yes, families can identify a successor guardian. That happens. But oftentimes, people end up with corporate guardians because there isn't anyone else. And I think a lot of times families don't realize a stranger could be appointed a guardian at some point in their person's future. Tim?
Just wondered, can you talk a little bit more about like voting rights and when somebody is declared incompetent, and when do they get to vote? When do they not get to vote? Is it like either or? Is it black? What happens with voting?
Depends on the box you check. So one of the boxes at the form is yep, this person shouldn't be, I affirmatively think that this is a right that should be taken away. Disability Rights Wisconsin actually did a full-on presentation about how do you keep your right to vote or ask for it back, because the standard, it's interesting, under Wisconsin law, if you're an able-bodied person, you can vote if you're over 18, you meet the residency requirements, and you have a photo ID. And if you are a person who is lost the right to vote under guardianship, you kind of have to prove that this is something that you can do in a way that an able-bodied person doesn't. So, you know, Disability Rights Wisconsin has a whole presentation about, if you're petitioning for guardianship, here are the steps that you should take to make sure that you are advocating to keep your right to vote. First, don't check the wrong box. But secondly, come prepared to advocate to the judge on why this individual should retain their right to vote. Because the judge, you know, the judge is going to want to hear a case to be made that that individual meets that they're declaring legally incompetent to do other things, still meets the criteria needed for voting. And I can search for, Tim, I'll search for the webinar on that and the materials. But again, court's in charge. You can come prepared to advocate, and it might not go your way. The easiest thing to do is not lose your right to vote in the first place. That presentation also goes through, if you've lost your right to vote, how do you petition to get it back and have those rights restored? So the easiest thing is don't lose the rights, which don't check the wrong box, and come prepared to advocate to the judge as to why that right should be retained, that you meet the criteria to be able to vote. By the way, other things that people don't realize, a lot of times hunting and fishing is jeopardized because under guardianship, you know, the right to, you know, firearms are restricted and other things. So that's another common thing that people sometimes don't realize happens to an individual. We've kind of talked about this. People with disabilities are really rarely consulted about decision-making needs or guardianship. This is often something that happens to them. So the thing that most affects every aspect of their life is not talked about with them. And frankly, for most of us, if we were asked the question, would you like so-and-so to make all these sets of decisions that are important to you forever? Like, most people would answer no. So, you know, there is that. And a lot of times people are really caught off guard, like this is happening to them and they may not even realize what is fully happening as the process is happening. A lot of times, and this is important, I feel like a lot of family members don't intend for this to happen, but a lot of people with disabilities describe, once there's a guardian in place, even if it's mom or dad, that the guardian starts making more and more decisions, even beyond what the orders allows them to do. So, you know, that's an important piece in terms of, again, are we training people to be more independent and more able to recognize their abuse, to stay safer, to live independently, or are we training them the other way, that somebody else is making all of my decisions and I have no control? Like the guardian, you know, is a guardian can either facilitate either path. We've kind of said this, but it bears saying that this is the place when all other tools are not going to work. And for some people, yes, okay, it's the first place you start because it's clearly this is the only option, but that's not for most people. Guardianship is an inflexible tool. So if you're going to use an inflexible tool, it better be the right tool for that situation, and that situation better be constant. It's not to change. I throw this up here because, you know, there is this myth that guardians make all decisions. That's actually not what the law says. In practice, many guardians do not behave in a way that really reflects the spirit of this law. As a guardian of the person, you're supposed to be trying to provide or place the least possible restriction, promote the most independence, most integration, and make efforts to identify and honor individuals' preferences. That's kind of the spirit of the law. But what many people with disabilities describe happening is the opposite. Okay, too much time on that. supported decision-making law. This is a different option. This is an alternative to guardianship. And it's based on the presumption that is the underpinning of our state law. Everybody's capable of making their own decisions. Supported decision-making says everybody should have the right to make their own choices and that you can get help making choices without giving up your rights. The reality is all of us use supported decision-making every day. Every time you ask for advice on something and then make your own decision, that's really supported decision-making. My silly example, this Christmas, I was going to go out on a limb and buy an immersion blender, my first immersion blender ever. And I asked my friends, hey, do you have one of these? And like, what can you, like, is there a brand? Do I need the attachments? You know, what can you tell me? And sure enough, I had two friends who were like unknown closet experts on immersion blenders. And I got a whole bunch of like, here's the different things to consider. Okay, lots of information. And I made my own choice. That's supported decision-making. The fact that we need a law to allow people with disabilities to do this, something that able-bodied people do all the time, is a reflection of the incorrect presumption that people with disabilities should have somebody else making their decisions for them. So people with intellectual and developmental disabilities can use supported decision-making agreements. It's also available to a whole wider group of people. We did not put an age limit on supported decision-making because older adults can need help at 60 or 65 or 85. And it seems rather silly to put a bright white line in the sand again based on age. There are lots of people that need a little bit of help at various times in their life. So this law applies to anybody who has a physical disability, mental health condition, or a degenerative disease or condition that interferes with self-care. Again, any age. We presume in Wisconsin that you can make your own decisions. And we presume that if you say you are a person who meets the criteria to use this agreement, that you do. So you don't need a doctor's note or a diagnosis to use a supported decision-making agreement. You have to say, I qualify for this. And most people are not, you know, I have yet to meet a person who is trying to identify with a disability to use a supported decision-making agreement. Supported decision-making agreements, I will emphasize this again, over and over again, they don't restrict a person's rights to make the decisions. The person is always the decider. They are always the ultimate decider. The supporter doesn't have new rights because of this agreement. The role that they are assigned and the topic that they agree to help with is determined by the individual who is writing this, who is doing the supported decision-making agreement. So this isn't surrogate decision-making. This isn't, you know, I step in and make decisions when I think the person's making the wrong one. This isn't guardianship light. This is, you have a distinct role as a supporter and the person's defined what that is. And you have been selected by them to fulfill that role, and it's on paper. What can a supporter do? 4 things. It can help somebody access information, only in the information that's relevant to this kind of decision the person is interested in. Can't get somebody's healthcare records if they want you to help with their taxes, for example. You may still have to sign a release form, you know, to access that information, but it's something that you can do. Helping the person understand that information, kind of important since, you know, plain language is not something bureaucracies do well. You can help that person understand the differences between those options. Think immersion blenders, you know, what are the different speeds? Do I need to know that? You know, that kind of like helping people compare and contrast. What are the pros? What are the cons? And then that person makes their own decisions. And the 4th one is assisting communicating the person's decision to others. I underestimated when we passed the law how important that was. It is one of the things that there are some people who only want a supported decision-making agreement for number 4. There are a number of people with cerebral palsy who have very distinct physical disabilities, or they have a speech impediment because of the cerebral palsy. And all they want is somebody with them who knows them, who can translate their communication style or nonverbal person to the professional. That's what they need, right? So the supported decision-making agreements really are very flexible. Somebody can have multiple supported decision-making agreements. This makes sense as we think about our own lives as people who use supported decision-making, and even though we don't know we do, I generally don't ask the same question of you know, can you help me with my taxes, as to whom would I buy a car, right? Like, those are different people in my life who would have expertise on those things. And no one person is an expert in anything. Interestingly, if you're the guardian, you get all the responsibility for everything a lot of times, but not with supported decision-making. It reflects how people live their lives, where there is a network of people that they know, and that network of people has expertise in various things. And yeah, the same person may be an expert in multiple things. And you may have a person in your life who's an expert in one thing and not in others. And you as the person can decide who those folks are. I keep saying supported decision-making agreements are flexible, unlike some of the other options, especially guardianship, which is the hardest thing to change. Supported decision-making agreements are very easy to update. Again, the person is always in control of not only their own decisions, but the supported decision-making agreement. So you could have a date when the agreement ends. You could try out an agreement and go, okay, maybe I need more help here or less help here. Maybe the agreement that you have at 18 isn't the same as the agreement you need at age 20 because you've had practice making decisions and you're better at it, or you've really decided that, yeah, I need extra help here. The supported decision-making agreement can change as the needs change and as the person grows. Yes, there are things in the law where you're automatically not a supporter because you've done something that is abusive. But the other piece that's important is either the person or the supporter can decide to terminate the agreement. Because if you're a supporter and your life changes out from under you, maybe you need to say, I can't do as much for you right now as I could for 5 months ago. And that's okay. That's not true with some of the other options where once you are, appointed, say, guardian, like if you want that role to change, it's likely that you're not going to be the guardian and somebody else will be appointed. So it's really important that supported decision-making agreements kind of reflect both parties' lives and that those lives can change. And there are times when they can give more or less support or they need more or less help. Skip that one. So how do you use supported decision-making agreements? The other thing that's flexible about these agreements is that they can be used for any decisions. When we went through that chart, there were quite a few tools that helped with financial things, right? Like conservatorship and rep payee if you needed it, or power of attorney for finances. Healthcare was covered in a power of attorney, maybe some release form stuff. But there are a lot of decisions in life that aren't about finances or healthcare. Where to live. If I'm an older adult, is this the time that I sell my house and go into assisted living or not? How do I choose a phone provider? All sorts of consequential decisions to people's lives, and supported decision-making can be used for any of them. And again, they can change over time. The law does include, we actually had to put the form in the law, in the statute. So these are all of the elements that are included in the form. What do you need to make a legal agreement? The form needs to be filled out with the name and contact information of the supporter. The person needs to decide what they want help with and the roles the supporter they want the role to play. And after that, you need the signature of the supporter and 2 witnesses over age 18, the magical number that means you're an adult in the state, or a notary public. And that is a legal supported decision-making agreement. There are certain kinds of decisions that are included on the form. What makes supported decision-making so flexible is this last bullet. This is really where you can customize it to whatever you need. Other decisions I specifically identified. Specifically identify them, there it is on the form, and you can get help with it. Supported decision-making agreements, the law assumes that if you don't check yes, that you don't want the supporter to help with it. Again, we're erring on the side of the person is in control of their agreement and they are the one who is saying, I would like help with this. So not checking yes or no, we're going to err on the side that they're not saying they want help. It's a double negative. So how do you use these things? When we were passing this law, we worked with a lot of aging advocates as well. And my friend Janet would say, you know, one of the great things about supported decision-making is it recognizes the reality of people's lives, and that we often have networks of people who aren't necessarily relatives that are willing to do something or have a close relationship with us. And she would often say, you know, sometimes it's extended family, like a cousin or, you know, a niece or a nephew, or even, you know, for a lot of older women whose husbands had died or children never had kids, children moved away, whatever it was, their closest relationships were actually a network of close friends. And supported decision-making allows those folks to have a role that the person has decided. It is a communication tool that somebody who is not a first order blood relative can say, hey, here's the reason why I'm here to do these things. And the professionals say, oh, okay, I get why you're in the room. There are a lot of people who, you know, don't have family as well. And maybe the people who are closest to them in their lives are the people who come in and do daily cares for them, or they interact with in a much more, in a very different capacity. We wanted to make sure that there was a way for those folks to play a part in people's lives and to kind of spread out the network of support. One of the family members who helped pass this law said, you know what, I can think of about 10 or 12 people in my son's life who are willing to take on and do a little bit. I can't think of one person who's willing to do it all. I can't think of another person who's willing to be a guardian. For many people, they need a little help for a long time. And again, flexibility. You see a pair of older adults here. You can transition for more support when that's needed. And maybe you do end up at the guardianship place. But a person who has Alzheimer's at 60 might not need a guardian until 80. And, you know, you get there when you get there, but you don't need to start there. Lots of folks have used supported decision-making in a variety of different kinds of meetings. Again, to kind of show, hey, I'm here for this reason, and the person's making all their decisions, but sometimes it's good to have another set of eyes or ears and somebody with you who knows knows what makes sense to you in terms of communicating. I use medical examples a lot because no one should go to a medical appointment alone. They talk fast with jargon and are often talking about things that are hard to hear anyway. But there's some real reasons to use supported decision-making, you know, not only to make sure that the person is clearly understood by the professionals. You know, we already talked about some of the people I know with cerebral palsy, with speech impediments, there's also a lot of people who are nonverbal, but that doesn't mean they don't have things to say. And sometimes it takes a person who knows them well to understand and interpret and convey what they're trying to communicate to the professional who may not understand their particular communication style. The reverse is also true, kind of making fun of, like, everybody's going to raise their hand and say they're a medical professional after I finish this presentation. But, there are lots of things where, people with disabilities are capable, but sometimes they need things explained to them in a way that makes sense to them. And that is a role that a supporter can play. You can be the person who's asking clarifying questions. You can be the person who is kind of playing a translator role from professional to the person. And oftentimes the professional will pick up on that from you. Like when you say, okay, what I'm hearing is, and John, that when you do X, Y, or Z, that they'll figure out that you're doing a storytelling and that you are translating what they're saying to the person. A lot of times they actually really appreciate, like, that's a good thing for them, because I don't think most people want to not be understood. They just don't realize when they aren't being understood. I'm going to skip through the professionals pieces. The supported decision-making agreement is always live, always up on the Department of Health Services website. And you can download it and you can fill it out and you can have it signed by 2 people who over age 18 as a witness or a notary public, and it is a legal agreement. The intention was that this is not supposed to be hard, and that people should have access to this option. You don't have to hire a lawyer. You don't have to go to court. There isn't a fee to do this. You can take care of it. We have some resources that we've developed for families called the Supported Decision-Making Toolkit. And it takes you through, some worksheets actually that are pretty helpful, both from the person's perspective and the family's perspective, that help you kind of work through what's the kind of agreement that you want or need, and how do you change it over time. Tim?
We have a question, especially now that this has been around for a little while, not long, but has there been any pushback from entities accepting supported decision-making documents?
There really hasn't been formal pushback. I think, I'm being careful how I phrase this. I think that the pioneers of supported decision-making in all states, not just Wisconsin, are challenging a system that presumes incompetence. And so for a lot of professionals, especially, this is something they're continuing to learn about. I do think that there have been certain professionals like Adult Protective Services and a lot of our DVR folks and a lot of teachers who are much more familiar with this, than they were 5 years ago, and that this is catching on. I also think that medical professionals are beginning to, a lot of times medical professionals are looking for the decider. And so part of our challenge is they don't see a distinction between any of those documents, right? Like a power of attorney, guardianship, anything is fine. They just want somebody else to talk to. That will not be not a problem no matter how many options you have. So there is an education piece with professionals, and we're working on it, and it's been useful. Surprisingly, the hardest group to crack are the bankers. Bankers seem to be the one group of folks that are hesitant about, not hesitant, but want to see this as something other than there is. But most people haven't reported to us that they've had any sort of problem, with people recognizing the agreement. Partly it's because the form is pretty clear too. It's like, here you can take it to the professional and say, I'm the supporter. Here's the issue that I'm helping with, and here's my role. And the professional will go, oh. I would say that, in the presentation, you saw some slides I just skipped through. like one of the things that's slowly happening is, various professions are, oh, this is a legal option. We probably need to change our forms or policies and procedures and make sure it's included. The same thing happened when powers of attorney became a thing in the state too. Like, this isn't different. It's just it's just the change right now. And I think about 20 states have passed similar laws. This is a national thing that is happening. So, there are more and more people who are familiar with this concept. Stop sharing.
Well, we encourage you, if you have any other questions, please put them in the chat. You can also unmute and we will recognize you or whatever and let you talk out loud if you'd like to ask that question. Remember, we are being recorded, so please no personal identifiable health information or credit card information. I did put a link in the chat. If before we go, you could fill out a short survey for us, that would be fantastic as we continue the Transition Talks Tuesdays and making them better. So any questions that you might have for Tami while we have her here? And Tami, just so you know, I did put down that we'd be sending the PowerPoint slides with,
Okay.
with the recording. I just wanted to check with you to see if there were any updates.
Yes, there are. I will send it to you.
Fantastic. Questions, comments? It's a lot of information. Okay, I am not seeing any, so I'm going to assume that we are tired and overwhelmed. So thank you all so much for being here tonight. Tami, thank you so very much. Hannah, did you have a question?
I did not. I just wanted to say thanks to everyone who was able to join. So.
All right, thanks so much. Reach out with any questions and I will get you that new the updated PowerPoint.